and Assalamualaikum everyone. Welcome back to Law Talk Show with Arisha, live from Sri Pentas TV3. I, Arisha Muizzuddin, your host for today. So today we have prepared something very special. So from last month, we have been getting a lot of requests from our vivid fans and viewers, which asked us to discuss the topics of case review based on the precedents of coercion, mistake, and fraud. So, we'll be having a very special panelists, including the well-established lawyers and a few of non-legal background individuals, which will help us on discussing today's topic. So, starting from last week, we have been started a poll on our official Instagram, and we have been decided to give a review based on the 3 cases which have been chosen. So, the first case is the case of Mrs. Albert Ding Lee and partner and Chu Chui Mei. The second case is Su Li Huat Palm Oil Mill Sdn Bhd and Stable Wind Sdn Bhd. And the third one regarding the case of Ishaq bin Ahmad and Unggul 88 Sdn Bhd. So, without wasting more time, I'll welcome Ms. Akmal Izzati to explain a fact and judgment of the first case.
Thank you so much, Arisha. So hello, my name is Nur Akmal Izzati binti Muhammad Azmi, and together with me is Puan Noliza. Say hi to the camera, Puan Noliza.
Hi.
So today, Puan Noliza will help us to further understand about this case by explaining the facts of the case. So Puan Noliza, could you please do the favor for us?
Assalamualaikum, saya Puan Noliza binti Kani. Kefahaman saya, kes ni bermula dari seorang wanita yang ingin bercerai dengan suaminya dan ia telah meminta untuk membayar pampasan di atas perceraian tersebut. Dia telah mengupah, saya namakan isteri tu Puan A. Puan A telah mengupah seorang peguam dan peguam ni telah mencapai satu kata putus dan telah menandatangani satu perjanjian. Perjanjian ni, dan apabila kes ni telah bermula, mereka telah berjaya dapat kemenangan dan memperolehi saman berjumlah 1.1 juta. Permulaannya, si suami mesti membayar 200,000 melalui peguam kepada Puan A. Selesai perjanjian pertama, Puan A telah membuat pembayaran kepada peguam beliau berjumlah lebih kurang 25,000. Memastikan perjalanan pembayaran ni berjalan dengan lancar, Puan A telah menandatangani satu lagi perjanjian dengan peguam beliau, di mana peguam beliau mesti memastikan yang suaminya mematuhi semua syarat dalam perjanjian tersebut agar perjalanan pembayaran berjalan dengan lancar. Tetapi Puan A mengatakan yang perjanjian kedua adalah tidak sah kerana dia dipaksa untuk menandatanganinya. Seandainya dia tidak menandatangani perjanjian kedua, pembayaran untuk 200,000 tidak akan diberi kepada beliau. Ini bermakna Puan A telah menandatangani perjanjian kedua itu tanpa kerelaannya dan ini merupakan satu paksaan. Itulah yang saya faham tentang kes yang dibicarakan sebentar tadi.
Thank you so much, Puan Noliza. So based on the facts given, the court held that since the second agreement was obtained by coercion in accordance with Section 15 of the Contracts Act 1950, the defendant was at freedom to put aside the contract on her own accord. This is due to the contract must be entered by the parties with free consent. If there is element of coercion committed by one of the parties, the contract can be set aside by the other parties. So that's all from me. Let's go back to Arisha.
Thank you so much, Puan Noliza and Ms. Akmal, for a very great explanation regarding the fact and judgment of the first case. Now, we know that the application of coercion in making an agreement may affect the validity of a contract. But we might be curious, right, on what grounds of principle that had been used by the judges in making a decision of the case. So now, I'll introduce Ms. Farah Tanya and Ms. Aina Rizati to explain the ratio decidendi that had been used in the first case.
This case, the reason why court made such decision is first because the court looks at the defendant's explanation, which she said that she was pressured to sign the second agreement. The defendant's evidence was intact, even after being cross-examined. The judge presumes that the defendant was telling the truth due to she gave a consistent answer every time the court asked. Next, the court stated that the plaintiff needs to produce Ms. Gunawati as its witness to dispute the defendant's evidence that she signed the second agreement under pressure, but the plaintiff had not done it. The reason that the court orders the plaintiff to call Ms. Gunawati because the defendant has explained that she only signed the second agreement because if she failed to do so, she could not get her check entitlement of 200,000 as the check was being withheld by a lawyer in the plaintiff's firm. Hence, the court concluded that Ms. Gunawati had unlawfully detained the defendant's property, which is the check, unless she signed the second agreement. Therefore, the court view Ms. Gunawati would be the best person to explain the conditions in which the second agreement was signed, as she was the one that forced the defendant to sign the contract.
Hence, as the plaintiff failed to produce Ms. Gunawati as a witness, by taking into account all the evidence, the judge finds that Ms. Gunawati had unlawfully detained the defendant's property and was not going to give it back to the defendant unless the defendant signed the second agreement, amount to coercion, and renders the full force of Section 15 of the Contracts Act 1950. Thus, the nature of the agreement is in fact consists of the element of coercion, as the defendant was coerced and under the pressure to sign the agreement. The judge also stated, since the second agreement was obtained by coercion, according to Section 15 of the Contract Act, Section 19 of the same Act is triggered. Furthermore, based on Section 19 of the Contract Act, states that the contract is voidable at the option of the party if the agreement is caused by coercion. Therefore, the defendant is at freedom to set aside the contract as a result of the coercion.
Wow! Such a very clear explanation from both of our beautiful lawyers just now. To simplify the content that have been shared just now, the judge usually will using a common law principle or any English or Malaysian cases or any provision which they find it suitable in deciding the judgment of the case. Now, moving on to the second case, which is the case of Suli Huat Palm Oil Mill Sundan Berhad and Stubble Wind Sundan Berhad. Basically, this case involving the element of mistake and giving a consent to enter into an agreement. So now I'll welcome Ms. Atira to discuss the fact and judgment of the second case.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Atira binti Saiful Hazmi. My metric number is 055340. So today beside me is Puan Mariam binti Zakaria, which is my mother. So today I would like to invite her to explain briefly about the fact of the case. Jadi Puan, adakah Puan boleh menerangkan sedikit apa yang Puan faham mengenai fakta kes ini?
InsyaAllah boleh. Plaintiff memiliki sebuah kilang minyak kelapa sawit di Segamat Johor dan memiliki lesen penghilangan bagi kilang tersebut. Namun begitu, plaintiff tidak mempunyai kedudukan keuangan yang baik untuk mengoperasikan kilang tersebut. Kilang tersebut beroperasi di bawah baras minimum dan tidak dapat diselenggara dengan baik, atau dalam lain perkataan, kilang itu sudah uzur. Kemudian, salah seorang pengarah dari syarikat plaintiff telah menawarkan defendant untuk mengambil pajakan kilang tersebut. Sebuah perjanjian telah dimeterai. Defendant telah mengeluarkan sejumlah kos yang besar untuk kerja-kerja penambahbaikan dan menaik taraf kilang tersebut. Lembaga Minyak Kelapa Sawit Malaysia telah memberikan lesen penghilangan sementara kepada defendant berikutan perjanjian pajakan kilang yang telah ditandatangani. Namun, plaintiff membantah kerana tidak berpuas hati dengan tindakan lembaga minyak kelapa sawit tersebut. Lembaga tersebut telah mengarahkan kedua-dua plaintiff dan defendant berbincang antara satu sama lain mengenai lesen penghilangan baru yang bakal dikeluarkan. Sebelum ini, Lembaga Minyak Kelapa Sawit Malaysia telah memaklumkan kepada plaintiff melalui surat mengatakan bahawa lesen penghilangan yang baru hanya boleh dikeluarkan sekiranya lesen penghilangan sedia ada milik plaintiff dibatalkan. Hal ini kerana lesen penghilangan tidak boleh dikeluarkan kepada dua syarikat yang berbeza terhadap satu kilang yang sama. Tambahan lagi, lembaga tersebut memaklumkan kepada plaintiff bahawa lesen penghilangannya tidak boleh dikekalkan berikutan perjanjian pajakan kilang yang masih berkuat kuasa. Sehubungan dengan itu, defendant telah memberi jaminan bahawa lesen penghilangan baru tersebut akan diserahkan kepada plaintiff sebaik saja tamat kontrak pajakan tersebut. Kemudian, plaintiff bersetuju untuk menyerahkan lesennya yang sedia ada untuk membolehkan lesen penghilangan yang baru dikeluarkan kepada defendant. Konflik tercetus apabila plaintiff bertindak untuk membatalkan perjanjian pajakan tersebut dan lembaga minyak membatalkan permohonan lesen defendant. Defendant kemudiannya memfailkan saman pemula terhadap plaintiff. Walau bagaimanapun, defendant menarik balik tindakannya dan memfailkan writ terhadap plaintiff dan lain-lain. Pihak plaintiff juga memfailkan saman pemula terhadap defendant dengan tuduhan bahawa defendant tidak memiliki lesen untuk mengendalikan kilang tersebut. Jadi itulah yang dapat saya nyatakan daripada pemahaman saya. Sekian, terima kasih.
Thank you, Puan Mariam, for the brief explanation just now. So, based on the explanation given by Puan Mariam, the issue that would arise in this case is whether there was a mutual mistake of fact in that both of the parties were under the mistaken belief that the plaintiff could still retain its existing license which issued by MPOB. The Court of Appeal was at the decision that the defendant's appeal was allowed and set aside the decision made by High Court. Previously, the High Court held that there was a mistake of fact and declared the agreement was null and void. The decision was in the favor of the plaintiff. However, the learned judges of the Court of Appeal believed that it was not mistake of fact but a mistake of law, which is in accordance with Section 22 of Contract Act 1950. Thus, the effect of the contract was valid and not voidable. The defendant was entitled to its right mentioned in the lease agreement and succeed in claiming the mill's possession. So, that's all for the judgment of this case. Let's go back to Miss Arisha.
Thank you so much, Puan Mariam, for a very great and excellent explanation regarding the fact of the second case. So, based on the judgment that had been explained by Ms. Akira just now, we know that mistake of law cannot make a contract as a voidable contract. So now, it's the turn for Ms. Sarah Sabrina and Ms. Alice Isati to discuss the use of principle by the judge in making a decision for the second case. Let's go!
Moving on to the ratio decided from this case, based on clause 3.17 of the lease agreement concerning on MPOB license, the lessor shall grant to the lessee the rights of operating the palm oil mill including oil mining, buying and selling of fresh fruit bunches, palm kernel, crude palm oil and others after signing the lease agreement. The lessee shall apply for and obtain the MPOB license in order to carry out trading activities in palm oil and oil palm business as soon as practicable. Referring to these statements, the lessee, which is the defendant, shall be given the rights to operate the mill in the mentioned situations, and in order to do so, the defendant needs to apply for the license issued by the MPOB. However, as stated in the Malaysian Palm Oil Board Act 1998 and the Malaysian Palm Oil Board Licensing Regulations 2005, no license can be issued synchronously to two different companies to utilize the same mill. Hence, the plaintiff needs to give back its current license to MPOB and fresh license will be issued by MPOB to defendant. Plaintiff's objection was unnecessary as the defendant was performing what it was supposed to do to obtain its rights. These can be referred to the requirements stated under Clause 3.4 of the lease agreement that the defendant needs to conform to the palm oil mills legislations and regulations. The parties also had mutually agreed that plaintiff would surrender its license to MPOB to enable a new license to be issued to defendant and it will be given back once the lease agreement expires.
Therefore, there was no mistake of fact pursuant to Section 21 of the Contract Act 1950. Plaintiff could not retain its license and in the meantime, defendant also applies for fresh license to be issued. Malaysian courts will refer to the common law cases of Shea Brothers Limited against Oshner and M. Pakiam against YP Deva Danjam. It is required to establish more than any sort of common mistake in order to declare a contract as void on the grounds of mistake of fact. Referring to a book entitled Understanding Contract Law by Huri and Yamuni, the mistake must involve something so essential to the contract regarding the condition precedent to a valid contract. This court will accept it as a mistake of law if there was a misunderstanding between the parties pertaining to the requirement of the mandatory compliance of the MPOB Act and the MPOB Regulations 2005 that a mill license could not be issued to two different companies over the same mill at the same time. Then, Section 22 of the Contract Act 1950 will be applied. The contracts will not be voidable as it was caused by mistake of law that is enforced in Malaysia. Differences between mistake of fact and mistake of law can be easily distinguished. A mistake of fact is a mistake not caused by the ignorance of a legal duty on the person making a mistake. Meanwhile, a mistake of law happens when a party comes to an incorrect conclusion regarding their legal effect despite having full knowledge of the facts.
Thank you so much, Miss Sarah and Miss Alice. So one of the principles that I'm really interested with are the section of 21 and 22 of the Contracts Act 1950 because based on my opinion, both of these provisions can give a direct way for viewers and also for me to differentiate the effect between the mistake of fact and mistake of law towards the contract. Oh, by the way, we have been getting a lot of positive comment right now from all the viewers regarding the explanation given by all of our panelists just now. So a round of applause. So without further ado, I will introduce Ms. Shahira Zakaria to explain the fact and judgment of the third case, which is the case of Ishaq bin Ahmad and Unggul 88 Sendian Berhad.
Assalamualaikum warahmatullahi wabarakatuh. This is Nur Shahira binti Zakaria with metric number 055262. Beside me is my mom and she will explain to us about the case that I had explained to her earlier. So without further ado, let's get it.
Assalamualaikum. Nama saya Rosidah binti Zainuddin. Apa yang saya faham daripada kes Ishaq bin Ahmad lawan dengan Unggul 88 Sendian Berhad dan organisation, apa yang saya faham, plaintiff telah membuat agreement dengan first defendant ke atas tanah yang berlot 3929. Okey, plaintiff telah membangunkan dan menyewakan tanah tersebut kepada peniaga pasar malam dan plaintiff juga telah membayar deposit kepada first defendant dan plaintiff juga telah menjalankan dan memberi peluang kepada peniaga pasar malam ke atas tanah lot 3929. Jadi Majlis Pembandaran Iskandar Puteri MBIP telah menyerbu dan merampas barang-barang peniaga pasar malam tersebut dan telah menyalahkan kepada defendant kerana telah menyewakan tanah tersebut kepada plaintiff dan melanggar kontrak antara defendant dengan Pesuruhjaya Tanah Persekutuan. Okey, di dalam agreement tersebut telah menyatakan tanah tersebut tidak boleh disewakan kepada third party. Tapi defendant telah menyalahkan dan menyalahguna kuasa dengan memberi kebenaran kepada plaintiff untuk menyewakan tanah tersebut kepada peniaga pasar malam. Jadi plaintiff tidak berpuas hati terhadap perkara ini dan telah membawa kes ini ke mahkamah. Jadi di mahkamah, plaintiff telah memberitahu perkara sebenar kepada pihak mahkamah dengan menyatakan agreement itu tidak sah disebabkan defendant telah memberi kebenaran kepada plaintiff untuk menyewakan tanah tersebut tanpa pengetahuan plaintiff bahawa agreement itu sebenarnya tidak agreement pertama yang dibuat antara defendant dan Pesuruhjaya Tanah Persekutuan telah menyatakan tanah itu sepatutnya tidak boleh disewakan. Tapi defendant telah melanggar agreement tersebut. Defendant telah memberitahu 3 perkara kepada pihak mahkamah. Yang pertama, sebenarnya tanah tersebut diberitahu kepada plaintiff untuk membangunkan kedai, bukan diberi sewa kepada third party. Okey, itu yang pertama. Yang kedua, plaintiff telah memasuki lot 3928. Sebenarnya lot kawasan mereka adalah 3929 tapi telah melanggar sepadan. Okey. Yang ketiga, plaintiff tahu tentang agreement tersebut di antara defendant dan Pesuruhjaya Tanah Persekutuan dan defendant memberitahu plaintiff sanggup menerima risiko tersebut. Okey. Jadi mahkamah memutuskan dan memberitahu sebenarnya yang bersalah adalah defendant, bukan plaintiff. Tetapi disebabkan defendant telah menyewakan tanah tersebut kepada plaintiff tanpa mengetahui agreement pertama yang dibuat antara Pesuruhjaya dan defendant tersebut. Second dan third defendant bersalah kerana telah memperdayakan plaintiff dengan tidak memasukkan deposit yang dibuat oleh plaintiff di dalam bil penyata keuangan. Okey. Pihak mahkamah telah menyatakan mereka bersalah under Contract Act 1950 Section 17 fraud. Second dan third defendant berjanji untuk pulangkan duit deposit tersebut sekiranya perjanjian kontrak itu terbatal tapi tidak menunaikan seperti yang diberitahu kepada plaintiff. Okey, jadi di dalam kes tersebut yang bersalah adalah defendant dengan second dan third defendant. Okey, sekian, terima kasih.
That's all from us. Thank you. For the judgment, the court held that the first, second, and third defendant amounted to fraud. The plaintiff will be entitled to the return of the deposit and all the rental pursuant thereto as prescribed by Section 66 of the Contract Act 1950. The court only allowed the claim to the extent of the return of the deposit and also the rentals to the plaintiff. The plaintiff also will be entitled to punitive damages of the second and third defendant of Rm 150,000 each to the plaintiff.
Wow, I just got caught up with the explanation given by your mother just now, Miss Shahira. Me myself feel very enthusiastic listening to the fact as well as the judgment of the third case. So now I'll invite Miss Aida Arifin and Miss Adriana Maisara to discuss and explain the ratio decidenda that had been applied in the third case.
The ratio decidenda for this case, the allegation of fraud needs to be proven on a balance of probabilities. The party claiming for fraud must reach the level of proof for at least 51% probability against the adverse party. The issue that arose in this case is whether the plaintiff was entitled to recover the deposit and rentals paid on the ground of fraud. The court touched upon the provision under Section 17 of the Contract Act 1915 to define fraud, concerning the existence of fraud on the second defendant and the third defendant. In determining the standard of proof, the court referred to the case of Sinaya and Sons Sdn Bhd and Daman Siti Sdn Bhd, where in order to prove fraud, it required a balance of probabilities. The further explanation for the term of balance of probabilities was described in the case of Miller and Minister of Pensions.
As Ms. Ida had mentioned in the case earlier, Miller and Minister of Pensions, then judge stated that if the evidence is such that the tribunal can say, we think it more probable than not, then the burden is discharged. But if the probabilities are equal, it is not for the further explanation for the term balance of probabilities. This case also becomes a notable case in Malaysia's jurisprudence, and Inas Faika binti Muhammad Helmi, an infant suing through her father, and next friend Muhammad Helmi bin Abdul Aziz, and Kerajaan Malaysia and others. Furthermore, the case of Ansong Rasad against public prosecutor is well explained about the concept of balance of probabilities. The court views the plaintiff's level of education as not understanding or appreciating the legal term of landlord and owner. By referring to all the principles mentioned, the court found that the second defendant and the third defendant had been proved on fraud, which is fraudulent representation, according to Section 24 of the Contract Act 1950. Hence, the lease agreement was void. According to Section 66 of the Contract Act 1950, the plaintiff can be entitled to recover the deposit and all rentals paid.
Thank you so much, both of our brilliant panelists, Miss Ida and Miss Adriana. So we need to remember, in proving the allegation for fraud, the balance of probabilities must be able to be proved. Now we have come to an end of today's show, so I guess all of the viewers have a better view on how to determine the facts, judgment and ratio decidendi of the three cases just now. So any of the students or the viewers which are interested to know more details regarding the tips or guidance on how to write a case review, may feel free to contact our panelists or lawyers just now. So we've provided their social media here, so feel free to ask the question to them. Thank you so much for staying with us until the end. See you guys next week, and we'll come back with more fun topic. Bye, stay healthy, and don't forget to wear your mask. Assalamualaikum.